that we will first, the way we have structured it is that first we will start off with explaining in simple terms what is DPDP law, the, how do you or any company get affected by it. Then we will move to CPG specific guidelines and how can a CPG company deal with the law. And then we will move to the data controller part. So with that, let me hand over to Amit, and he, in simple terms, will try and explain the law to all of you. Amit, over to you.
Thanks, Shashwat. Can we move to the first slide, please? Okay. All right. See, today we will be, covering a very important recent development in the legal framework that the Indian subcontinent and Asia Pacific in specific is witnessing, because data privacy law was not in existence before, before the DPDP Act came into picture. There were some rules here and there in the IT Act, like SPDI rules and so, but they were not as elaborate and as comprehensive as the current law. Now, the current law is very wide in its scope. Okay, it covers multiple entities and multiple jurisdictions, anyone who is processing our personal data. So now, what is personal data per se? See, personal data is any information that can identify or single out you as an individual person. Okay, so let's say my email ID or my phone number is my personal information, and that is, or these are fundamental examples. These examples can go in very, minute things like my behavior, how my neighbor perceives my behavior. For example, when a police officer looks out for a culprit, they don't have their name or email ID or phone number. Okay, what they know is how does that person look like? Okay, tall, brown hairs, short hairs, etc. So that is what is your personal information. Whenever any corporation, any company, even some renowned individuals, when they have this information about you, it's dangerous. And you should be in control of what information is being shared or what is happening on that information. Okay. Otherwise, you will keep on receiving, unwanted calls for credit cards, debit cards, and whatnot. Okay. So that's the, starting background which I wanted to tell you. Now, if you see the DPDP law, okay, it is drafted on the similar lines as GDPR is. GDPR is one of the comprehensive laws, and DPDP is also a very, very comprehensive law which covers digital personal data. The keyword here is digital personal data. Now, what is digital personal data? Now, the Act in its current form says that anything which you can convert in a digital format is digital personal data. Okay, any personal data that you can convert in a digital format. Now, the Act specifically excludes paper formats, okay, or paper files. Okay, anything which is documented in hard copies, which is not converted into digital format. Now, the reasoning which was given in the parliament as such was that digital acts or digital formats can be processed very easily. They can be analyzed. A lot of analytics can be performed on it very easily, but the same cannot be done in a physical format or hard copy structure. Okay, now there are certain legal bases which you require if you want to process any information. When I say process, if you are using it, if you are storing it, even if you are storing it in a pen drive, that is still considered as processing of personal data. Now, whenever any company, okay, let's say you open a Facebook account and Facebook is using your data. Okay, if you open an account on Zomato or any such company to order food, they are having your data. So all these companies are having what? They have your consent. The moment you install that application, you click on I agree or I consent to give all this information to you. Okay, so these kind of fundamental basis, or they call in legal terminologies, they are on a legal basis. You should have at least one basis to process the data. If you do not have any background or any basis to process the data, it will be considered as unlawful. Okay, you cannot process that particular information. Now we'll go to the next slide, please. Okay. Verify if we can move to the next one. Yeah. Now, where does this law apply? Now, it may sound to you that the Digital Data Protection Act is something which applies only in India, which is not the case. Okay. The law applies in India plus to anyone or any organization which is offering goods and services to individuals within India. So let's say there is a US company, for example, let's say Facebook, okay, which is offering its services in India to me or to Shashwat, okay, and we are both using it. That means it has to comply with DPDP. It cannot say that my servers, my processing is happening in US, my processing is happening in France. I am not doing anything in India. That will not exclude you from the applicability of this law. It's very, very serious affair. So it has extraterritorial applicability as well, provided if you are offering any goods or services in India. Now, goods can be anything. Like let's say when Toyota is selling you Fortuners, that is also considered as a good that they are producing somewhere else, but their digital navigators or their GPS navigators are able to locate where you are in India. Okay, so that's the applicability of the entire structure. Can we go to the next slide, please? Okay. Now, there are a few terminologies which are used in the DPDPA law. One is data principle, okay, which is you and I, okay. We as individuals, we are data principles, okay. Now, these individuals are the people whose data is being processed by organizations, by MNCs and or any company, okay, for that matter. Now, there is something called data fiduciary. Now, this is similar to the term controller, which is used in the European context. Okay. Now, this data fiduciary is any entity which is processing your data. For example, when let's say when you go to website and they collect your phone number, or when you go to McDonald's or KFC and they collect your phone number, that they are considered as data fiduciaries, the people who keep your data on your behalf. Okay, like they are trustees of your data. They are not the owners of your data. You are the owner of your data. That should be crystal clear. All right. Now, there are certain rights that you have as an individual, as a data principal. Like you can access, you can ask them to correct your information, you can ask them to erase your information, or you can ask them to forget your information. All these rights you have under DPD. These rights were not present in any previous law which in the Indian context. Okay, and before GDPR, it was not in existence in EU as well. So what do these rights essentially give you? These rights are, play a very pivotal role. For example, if I want to understand what is Facebook doing with my information, or what is Westside or McDonald's doing with my information, I have that right to access. I can ask them for a copy of it. Okay, give me a copy of whatever information you have about me. Okay, tell me, is it mandatory to give my phone number while I place my order in Domino's or McDonald's? It is not, but they won't tell you. Okay, they will politely ask you, sir, may I have your number? Seems like mandatory, right? But it is not. So there is no transparency in the structure, which is also an obligation, under the DPDPA law. Okay. Now, what is the remedy if the companies do not give you this information? There's a special grievance redressal mechanism which has been provided. So, which is an internal, affair of the company. So, the company will have a committee-like structure, which will be responsible to address any queries, any thing which you are raising, which is not getting resolved. Okay, this is not present in GDPR. GDPR does not have an internal grievance redressal mechanism. Okay, GDPR just says that if you are aggrieved, directly approach the authorities. We'll take it from there. Okay, now that is something which is new, and if that internal body also is not able to understand or correct your issue, then you can directly go to the Data Protection Board, which is the apex body under the DPDPA law. Okay, we move to the next one. Next slide, please. Okay. Now, if you compare, like I was interested in telling you a few important comparisons between how DPDPA differs with GDPR and other international laws in Australia and multiple other countries, or US for that matter. Now, if you see DPDPA, it is very it focuses a lot on rights, which is not the case. Now, it is individual friendly, which is not the case in US or Europe. Okay. Now, if you see, if you see the US environment, it is very business friendly. If you ask them for a consent structure, they will say, we will automate your consent, like your consent is already taken care of. Now, if you don't want that information to be processed, then you have to unsubscribe to it. Okay, so they are very business friendly. They are not individual friendly. And in the opposite of it, EU is very individual friendly, or they are very much inclined on individuals. That we want to protect the individuals. They keep businesses on the other side. Okay, so that's the key differences which you have. But plus to that, if you see the DPDP law, it is similar to GDPR, but not similar to US and or Australian framework, because US follows a sectoral framework. Like healthcare, it will be treated as a separate sector, education, separate sector. All these sectors have separate laws, which is not the case in India or in EU. Okay. And Australia's law, is a very short one. It is not as comprehensive, and the enforcement is also not that great when you compare it with GDPR. All right. So these are just key outlines. You will get a good chance to ask any questions or any clarifications which you require. So, yeah. Can you move to the next one, please? Okay. Now, whenever I work with any industry or any company, so I have worked from automobiles to telecom, almost many industries. So, okay, whenever I go there and interact with any management people, the first question they ask is, we already have 27,001. Okay, we already have a security framework in place. Do we still require a privacy framework? How does it change, or what does it change? Is it even required that we have a privacy program or any privacy structure in place? Now, my simple response to them is, if you breach a security framework, there is no liability. Okay, if you do not install an antivirus in your system, there is no liability. But the moment that antivirus is not there and the personal data of an individual gets leaked, then you have liability under laws. Okay, so for security violations, you don't have a liability per se. Okay, under the in the Indian structure as such. Okay, however, if that information gets leaked, that is a very crucial phase of it, because if you see the IT Act or if you see the DPDP law, it focuses a lot on privacy rights. Okay, so if, for example, if you consider EU, even if you blur out some part, or if you do not make that I disagree option very clear, then also they have fined companies. Okay, so or I withdraw my consent. If you do not show that unsubscribe option, they have fined the companies. Okay, like there's a popular application which is like which everyone uses, like WhatsApp, Facebook, all these applications. Almost all these companies have been fined. Facebook has been fined to such an extent, okay, in US and EU both, that now they have made a video privacy policy instead of a written privacy policy. Okay, just to make people understand what is happening and how are we processing your information. So it has got to that extent. All right. So when you say you comply with ISO standards, you are complying with certain controls which are independent of law. Okay. They help you in complying with DPDP, the security requirements under DPDP, but they are not, helping you to comply with all the provisions of DPDP in totality, because DPDP is a rights-based mechanism. When you talk about ISO, it's a controls and security-based mechanism. I want to protect my systems from unwanted intrusion, so I will implement ISO standards. Okay, but that is not the case when you talk about DPDP. It's a human rights-based structure. Okay, like I as an individual, I am not worried if your systems are protected or not. I am worried if my data is protected or not. So you are responsible to protect my data, and that's my overall involvement in the DPDP. Okay, so to just help you understand this better, specifically in the FMCG, and FMCD market, I'll give you an example. Can we go to the next? And this is the practical example that I have experienced personally. Okay, so I'll give you a brief background. Can we go to the next slide, please? Yeah. So this is, if you can zoom it a bit. Okay. So this is what happened to me when I visited the West Side store. Okay. Like this was around 6 years back. I visited a West Side store. I was in my, when I was on my way to some place. Okay. And at that time, nothing came to me. They said, sir, we are eco-friendly. So we want to send you the bill online. So can you please give us, can you please give us your mobile number? I said, okay, please have my mobile. Now, this happened when Facebook acquired Meta and the business chat feature came in. Okay. Now they started sending me a lot of, promotional content from Westside. Westside is a company owned by Tata, if you're not aware. Okay. They start sending you a lot of promotional content. And even if you, like, then I wrote an email to their support team. Can you please delete my data? Okay, I don't want, like, this is happening after 7 years. Okay. Last purchase I made sometimes in 2016, and they are communicating to me 2022, 2023. Okay. So you can imagine the level of, processing which is happening on your information without your knowledge. So nobody is telling you, okay, that we will be analyzing your purchase patterns. We will be, giving you discounts or removing discounts and all those things. But all those things are happening in the background. So when I asked them that, can you please delete my data? They said that we regret to inform you, but we cannot delete your information. Now, with the DPDP Act coming into picture, this will become a right for you. Okay. You will be rightfully claiming that you have to delete my information. Otherwise, I am going to the data protection board if you do not do this. Okay. So because of this, a lot of companies are, a little worried. Okay. And as a consequence of this, a lot of companies are, deliberating their privacy structures. How should we redo it, or how should we, create a better, more individual friendly or user friendly mechanism so that it helps them and it helps us. It's a win-win for both. So this law is to equate between individual rights and business rights. This law is not to kill business. It is just to support individuals. So on that note, I'll wrap up my presentation. Over to Samya.
Awesome, Amit. Thanks for that insightful presentation. Couple of things which I took as a takeaway. The first one being that now you have rights which were not there earlier. Second, GDPR versus DPDP. Perhaps this particular law is much more comprehensive because it will also give a grievance mechanism, and then you approach the board. And of course, the Facebook video uh, privacy thing, that was news to me. So with that, what we'll do is let's have a quick poll so that we can get a sense of how we are doing in terms of the knowledge session. Garima, I would request you to please start the poll. Um, Folks on the webinar, if you can answer it, then we can quickly take that poll and then move to Soumya. Amit talked about the data fiduciary part. Now, from the CPG company perspective, how does that work? That is something that we will cover, and Soumya will cover just after the poll is launched. Are you guys able to see the poll?
Hi Shashwat, just give me a minute. I am just launching the poll. For that, I need to stop sharing my screen first. So let me
No
just.
problem. Let's do one thing. Let's
Yeah.
jump directly into Soumya's presentation and then we can go into the poll. Soumya,
Perfect.
over to you.
Awesome.
Thanks, Shashwat. Good afternoon, everyone, and hello again. So I think that was a fantastic coverage, Amit. Like you went through the entire act very well. So what I would like to do now is to maybe zero in a little bit more from an organization perspective, very specifically from maybe like from the data fiduciary aspect of it, right? So let me quickly go over this overview. I think the rest of it Amit has already covered, but I just want to have a little bit of a deep dive into what are the obligations as a data fiduciary, right? As an organization that is collecting the data. And here we are looking at, like, again, like Amit mentioned, it can be any individual, right? Who will be your data principal. It can be your employees, it can be your customers also, but we'll focus a little bit more from a customer aspect for today's discussion. So some of the obligations that a data fiduciary as the organization they have is, in a very first stage, is that you need to have a basis for processing, right? Why is it that you are collecting this information and what are you going to do with it? That has to be institutionalized from the way of not just identifying what is your basis for processing, but you are building it into your entire system, whether it is based on a consent or whether it is based on any other legal need for processing, right? So that is the very first thing. Then you have to have risks and processes and controls that are built in, which would include having, say, like an incident management process, which includes, of course, your monitoring of how the data is being accessed so that the confidentiality and the integrity of the data is being maintained, and having a breach notification in case either the confidentiality or integrity is being breached, right? And then we'd have to also have a governance mechanism in place wherein we'll be able to respond to the data principal rights. I think one of the responses was showcased by Amit, even though it was not exactly what he wanted to hear, but at least it is a response, right? And that governance around identifying any requests that come in and providing a response also has to be built in, and you need to ensure where you are transferring the data to, and that is being done under a valid contract. Now, this act does provide that there are two types of data fiduciary. One of them is, of course, like, your regular data fiduciary who collects the information. But once the DPBA or the Data Protection Board of India is in place, they will be able to classify certain data fiduciaries or a whole class of fiduciaries as significant data fiduciaries. If you are classified as one of them, your obligations are increased, that you would also have to have a named data protection officer. You'd have to have independent audits that are being conducted. You have to have data protection impact assessments also that are in place, right? So those in a short term are obligations of a data fiduciary. Now, how do these data obligations maybe translate into what an organization has to do in real life? I just have a very, very high level example. Garima, if you could please move to the next slide. So I will take the example of online shopping website, right? So we have various processes, various layers when we look at any process. So very first is like, your procedure or your human layer. Then we have like what the transactions that happen at the application layer and what happens at the database layer. As an organization, you need to have controls that are built in each of these layers. So let us start with this entire process, right? When we are looking at, like, say, like an online shopping, now it can be an aggregator or it can be a small online portal, right? Or your website. But at a high level, this is the process that it goes through. So in the very first thing is like you will have like a website or maybe even an app, mobile app that is there. So when a user goes in and registers, we need to ensure that consent is taken. Like most of all, while there are other bases for processing, for this example, it is most likely going to be based on a consent mechanism. So we need to ensure that consent is taken. And now once the consent is taken, the organization has to make sure that it is logged. What needs to be in the log is the date and time wherein the consent was taken, what was the basis of the consent, the underlying notice that was there as part of the consent, and what was the reason for which the consent has been taken or consent has been provided, right? All of those has to be logged. We'll also have to have age gating that is built in so that appropriate consent is taken either from the data principal themselves or from the principal's guardians or parent, right? Then we have to make sure that like we educate that person about, or the data principal about their rights and about the grievance mechanisms. It is a good practice to have a DPIA conducted at both the application and the website and the process level. If you, it is mandated, of course, if you are a significant data fiduciary, but even for the others, we do say, so that you build in privacy into the entire process and the systems also that are involved in it. So once we have the application, we go in to have a registration, right? Wherein, and this is where we will have notices coming up, consent managers kicking in, and very similar to where in the very first place, right? Now, wherever we are storing this data, at the app and the data level, we need to make sure that privacy has been included as at a design or a default level. While DPDPA does not call out for us to have privacy by design or default, well, like the way GDPR does, this is probably the best tool that we have to ensure that privacy is maintained and an accountability also is provided, and we avoid any kind of maybe a breach or even any kind of penalties that are there, which is a very good practice to include privacy by design and default, and have secure application coding processes that are built in, so that we will be able to prevent any kind of a breach. Now, very next place is, of course, will be where once we have obtained the consent is when we start obtaining the information. What kicks in over here from a DPDPA perspective is that we only collect that information which is absolutely necessary. So we have a minimal data, and also it is limited to the purposes for which we are collecting that information, right? So of course, from there, of course, you have all the product searches which may kick in, your marketing and analytics software. So whenever we are especially if profiling is happening or tracking is happening of the customer, it is advisable that there is enough masking, encryption, or pseudonymization or anonymization that is also being taken into consideration throughout the entire life cycle, right? Some of the other things that will come into place, right? Is when we go down, when you select a product, when you're maybe buying the product, and then when you're going up to a payment, you may have a payment gateway wherein you are moving it to another third party, or when you're shipping the product, right? If we are considering it as a physical copy or physical product that is being shipped, is that we kick in a lot of other third parties that come into place. Maybe a third party who is processing your payments, in which case it's a very good practice. It is mandatory to have PCI DSS. It's also a very good practice to make sure that we are only sending in the information that is required. We are letting the person know that they're moving away from our website or our application into a third party website. And any third party for which we are sharing that information, right? Either it is as part of analytics, as part of order fulfillment, as part of payment fulfillment, then it is good that we have a valid contract. It is also mandatory, actually, not just good, that we have a valid contract under which we are engaging with them. At a high level, what the contract will have to cover would be to say what is that information that we are sharing with the third party and how that information has to be processed. In addition, we can have what are the privacy and the security requirements that the third party has to follow, and any kind of an oversight that we want to have over this entire process, right? And breach notifications that need to come into us from our third parties. So all of those also need to be taken care of, all the way up till our order confirmation or tracking and the support and feedback received. So I just wanted to give this quick overview about what you need to do as part of the processes and the controls that need to be built into the businesses if we have to adhere to the DPDPA. This is pretty much what I wanted to cover as an overview. But of course, if you have any questions or anything you want me to elaborate on, would be happy to do so. Over to you, Shashwat.
Thanks, Soumya. Very insightful. I have a quick question that I got on the chat. One, what is the impact on the mom and pop shops if they are collecting data? What happens to the data fiduciary? And the second one, if suppose there is a large retail or maybe a modern trade is collecting data, what is the responsibility of the brand? If you can cover those two, that's a question that we got just now.
Sure. So I will club both of these questions into one, because the law does not look at it more from like a size, right? Except if you are like, if you bump up from like, say, a data fiduciary level to a significant data fiduciary level, then your requirements will take it, will be slightly different or slightly enhanced as a data fiduciary. Else, whether it is a mom and pop shop or whether it is like a large conglomerate, or whether if it is a multinational, like a gigantic multinational, right? Your requirements as to maintaining the privacy of the data principle remains the same. Now, what I mean by that, and again, I think like Amit also can chime in, is that, see, as long as the data is being collected for a commercial purpose, this law is applicable to the entity, whether it is a mom and pop or not, right? So what they would have to do is pretty much what I had mentioned over here, is that you need to ensure that when you are collecting that information, you are collecting only the information that you need, and you are deleting that information once the need is gone. Now, how you define the need is left to the organization to have a logical method of figuring out till when the need extends, right? And when they will delete that information, but that has to be categorized. Then you need to figure out on what basis you are collecting that information. In the example I gave, it is most likely going to be based on consent. I cannot imagine a scenario where it would be any other purpose, but the DPDPA does give like other purposes, right? Like certain employment reasons, or if it is for law and order purposes. So or if it is on a contractual obligation. So there are all these other areas where you will be able to cover it up. But if it is consent, you have to ensure that you've taken the consent, you are managing the consent, you are logging the consent, and you are processing the entire life cycle based on the consent, right? Or throughout the processing, security has to be taken care of, and there is adequate technological and procedural controls that are defined. Now, when we are looking at a mom and pop store, we can make sure that, like, say, like your access, you don't need to have like a specific access management tool that is in place. You can just maybe like, keep track either in an Excel sheet or even in your mind as to who gets access and what are the roles that are provided. But let's like flip to like, say, maybe like a giant, like a company that is significant presence. You may want to invest in adequate, like, tools and technologies around how you're going to manage identity, how you're going to manage privileged access management. All of those, you would have to have tools and technologies to support it because of the scale that you are working on. But at the end of the day, you have to make sure that access is only provided on a need basis, right? How you do that may differ on scale. Other things that need to be considered during the processing is that you are tracking and seeing that there is enough monitoring of that data to make sure that confidentiality is not breached. Again, for a mom and pop store, you may want to just have like an encrypted or a password protected file. But if you are looking at a conglomerate, you may want to have appropriate tools in place for masking, for encryption, for monitoring. You may want to have an SIEM in place. You may want to have a SOC also that monitors, right? So your scale differs, but your basic responsibility remains the same. Now, if you are a significant data fiduciary, then of course you would have to make sure that you're doing a privacy impact assessment whenever there is a change, and at the very beginning of having a process, of setting up either a system or a process or a business or an application, right? So at that point, you would have to have a privacy impact assessment. You need to make sure that you're auditing it on a periodic basis. Periodicity has not yet been defined, but if you are a significant data fiduciary, you have to have periodic audits, and the audit has to be done by an independent third party. Then you have to have a DPO, and by nature, the DPO will have to report up to the board, and which means that you are reporting to the board on your privacy metrics. You will have to identify and see what are your important privacy matrices that you are going to report to your board, right? Like such as how many data subject requests or data principal requests you have obtained, how many breaches have happened, or how many breaches have been prevented. All of those you can decide and say what are all your privacy matrices, and you would have to report to the board. Of course, for a mom and pop store, there is no such requirement, and there may not be a board, and there is no requirement. But at the end of the day, privacy is being maintained from the time of your collection of your data to the deletion of your data. I hope that answers the question. If you have any, please.
Yeah, Soumya. Thank you for that. And that kind of covers it. Guys, on the webinar, please start asking questions. We are there to answer it. With that, let me now move. So we covered the first one, which is the principal. Then we covered the most important part, which is the fiduciary, which is the CPG companies which are out there. Then the third, there is a very important aspect, which is the data processor. And let me come to Varun for that. Garima, you can stop the presentation and we can directly go live on the question part. Varun, one big question which I had is, from a data processor point of view, what are the main areas that maybe a CPG brand should keep in mind when they are hiring any data processor? Like, folks like either field assist or any other service provider or any other partner. What should the brand look at?
Sure. I think a very important question, Shashwat. So up until now, I think the cost, integration, capability, scalability, these were the, say, common terms that were majorly applicable for any CPG brand or any other business when they were looking out for partners of data processors. But now, obviously, with all other existing compliance and DPDP also coming into place, I think there are four main areas that a brand should look at. One is data security and privacy. So when we say data security and privacy, we need to see whether the processor is compliant with the DPDP Act and the rules laid out until now. Obviously, it's a ever evolving, I would say, landscape, and there would be more rules coming up. But until now, all the rules that have been laid out, whether the processor is compliant to it or not. Then in security and privacy, data residency, data breach history. So whether the processor had a breach history and how he has responded to those whenever that incident has occurred, whether they have a strong incident response plan in place or not. Then security measures as well in terms of customer data and also transaction data, whether correct, I would say, masking or encryption of data is in place, whether we have correct access control and incident response plans in place. So these are main areas in data security and privacy. Then other is data processing operations. So for transaction data, we already know, I think it is more in terms of capability, but with DPDP in coming place, I think there are four main things. One is purpose limitation. So you are only collecting data for with a very laid out purpose. I am collecting data for this specific need, and purpose limitation should be part of it. Then there is data minimization. I should collect as minimum data as possible from the data subject. Then consent management, as I think Soumya and Amit already covered it, it should be part of the tool or the platform that you are going to work with. And then data subject rights, because now data subjects have received legal rights. So as Amit showed in his example, in that, say in January, that response would have been appropriate, but today, say company cannot respond like that. So our processor has to have mechanism in place so that if a data subject wants to alter his data, he wants his data removed, modified, there should be a mechanism for data processors to address those needs in the behalf of a data fiduciary, because that is something that he is responsible for. then I would say reputation and expertise of the processor also comes into place with this coming into place. So industry experience will help, I would say, fiduciaries to choose right partner. Then financial stability and reputation in terms of data comes in place because there are a lot of compliance coming into place with DPDP, and now when it will be more exhaustive. So financial stability of the processor and its reputation is important because then it will be able to comply with the set of rules that are there. And the last point would be transparency and communication. So transparency and communication in terms of how we are handling data, what is the data processing agreement between the fiduciary and processor. It should be very clearly laid out. And then internal, I would say, policies in terms of how, say, employees of data processors are being educated about the compliances, about the obligations they have, how to handle data. So I think these are the key parameters or pointers that a data fiduciary needs to look at when they are choosing a data processor in any field.
Cool. I think those are very important 4 pointers. I mean, just a quick question again. From field assess point of view, how have we covered all the 4 areas? If you can just elaborate on it.
Sure, sure. So what we have done so far, and I think it's also a work in progress still, because I think a lot of new information is coming up on a daily basis. So I would say one is part of data security and privacy. So because we were already compliant with say ISO 27001 and SOC 2, and we also have a say we use Printo as one of our tool for live incident management and evidence collection. So anything that is happening in our entire ecosystem, be it our, say, from email to our, say, Azure infrastructure to our, say, application logs, everything is being logged and monitored. So I think that is one key area that we have worked upon very strongly in, I would say, last couple of years, and specifically after COVID. Second, it is consent management. That is also something that we have taken up. So for example, all our client facing, I would end user facing application, be it a retailer app, be it our salesman app, be it a distributor management system, we have started incorporating consents to wherever we are trying to capture data that is classified as personal data. And obviously our internal mapping exercise is also going on, which is a personal data, because that is also something that you need to cover. Then data transfer and localization is also something that we looked at. So we have already, this is something that we have done proactively, that we have already moved our entire data bases and data centers to India. So this is something that may not be very strongly laid on, but because it's a proactive measure from our side to respect and try to adhere to those. So we have already taken that back. Encryption and access control were already our strong suit, and we have already covered that. So I think that was already there. Then apart from that, internal training program in terms of data security and these new applications coming up in terms of how to handle personal data. So this is something that we are already working on, and we have tools for it to train our employees to handle these scenarios. Apart from it, I think last scenario is because Field Assist being I would say, a company that has operation outside of India as well. So we have also trying to cater to, say, other aspects of, say, laws outside of DPDP also that could be applicable for us in terms of a specific nation or geography, and also scenarios where we are catering to, say, a customer in India, but we have some international, I would say, operations or data operations as well. So we have tried to cover all these possibilities with our data governance plan also, and a data protection officer also. So these kind of, I would say, roles also we are creating so that we can streamline our data flows. So we can have audits of our data flows, how and which type of data we are collecting, whether it is, when I said purpose limitation, data minimization. So we are trying to evaluate our internal data flows also on those parameters. So these are the things that we are taking into place and working upon it.
Awesome, Varun. Thanks. What we'll do now is we'll do a rapid fire round so that we can quickly cover some scenarios. And those are all CPG scenarios, very common scenarios which CPG companies face. And maybe we can go one by one and you can answer to it. So let me take the first scenario where suppose if you are, and again, I'm just taking one brand name and it is not very specific to that brand name. Suppose if you are buying a fridge from Whirlpool and from their website, and Soumya, you covered a lot of it. In this particular case, what is the responsibility of the FMCD company?
Yeah. So I'll go first, Shashwat. So I think I went through that entire scenario, right? Like so that would be their responsibilities to make sure that whatever data they are collecting is minimized, and then the data is being stored, making sure that like it is securely stored and securely maintained. The data is also stored for a specific amount of time, so that it is not like a perpetual one, unless of course like somebody goes in and creates an ID, then you can maintain it, but you may want to see how long, what are the information you're going to collect to retain for the specific period. In any kind of like a third party you use, like say maybe you are using like a distributor or a even like a third party logistic provider to go and deliver your refrigerator or your goods. At that point you have to make sure that you have a valid contract under which it is being maintained, and then that is being that any data that is shared again is at a minimum. The data that is shared is protected, and we ensure that the processor also protects the data the same way that we would protect it, right, from a privacy and a security angle. The other thing is, if we are going to use it for any kind of profiling or any kind of data analytics, the law does not say that no, you cannot do it, but you may want to go in and see whether A, you have appropriate consent, or B, if you are adequately anonymizing it, or maybe aggregating it so that it no longer falls under the personal data ambit, right? So that is the other thing that is used. Then of course you have like all the other controls that need to be in place.
Awesome. Understood. Now, suppose, let me throw a curveball to it. Amit, suppose if this guy is based out of EU and probably he has gone to the website and just entered it and they want to export. What happens in that scenario? And this guy is an NRI who has ordered it.
Yeah, so let's say if you are an NRI and if you are, so there are multiple scenarios in such circumstance. Either you are in EU and you are giving that information. That way, GDPR and those laws will directly come into picture. Second scenario is you are sitting in India and then you are giving the data to the, let's say, a company based out of EU. Okay. In this scenario, like it will depend on the facts and how they collected the consent, what happened, what all information they gave to you, on what basis they have collected this information and all those. Okay. The third scenario is you are, a company which is selling their goods and services in India, like for example, Volkswagen, okay, or for example, any other manufacturer or retailer for that matter. And you are sitting abroad, you do not have, any major offices, you just have a branch or something. In the third circumstance, the DPDP is still applicable. Okay, so you have to understand that in the first instance also and in the third instance also, the DPDP still applies. Okay, because regardless of whether you are in India or not, okay, or if you are collecting the data of persons in India. But see, this law is not a citizen specific law. It does not say that it does not differentiate between NRIs or OCIs or citizens. It says a residency based structure. So if you are a resident of India, it doesn't matter what your citizenship is. For some restrictions are there, but still it's a residential structure based law. So if you are in India and the data is being collected here, or if you are a permanent, let's say citizen or resident of India, and then a foreign company is collecting, DPDP applies. So all the obligations come into picture.
Understood. Let's have another curveball to it. Suppose if the data processor is in Turkey and the information about Indian citizens or the PII information of Indian citizens is actually processed in Turkey by a service provider, maybe a software service provider. Varun, what happens? And how can they ensure that it is compliant?
So in this scenario also, DPDP Act will be applicable uh, to a processor in terms of partially, but to a fiduciary completely, because data still is being collected from India. Data is still, so then data is also transferred to a, say, local data processor, say, based out of Turkey, but then transfer requirements also needs to be met. And then the agreement between, say, fiduciary, that is Whirlpool, and a data processor, that also has to lay down all the things that the data should be kept, say, in an encrypted or a secure form, so that it does not leak out. So you need to, both local data processor and Whirlpool will have the obligation, with Whirlpool having the majority of obligations to ensure that first of all, data processing agreement between those two entities complies with all the rules laid down by DPDP Act. And then transfer requirements are also met, because the data is being transferred from India, collected and transferred from India to Turkey, say a database out of Turkey. And then all the, say, rules and measures are in place so that data is secure and is not misused, or say it is not used out of the purpose.
Awesome. We have a couple of questions. The first question is from Mahendra Borse. How long specific days we can maintain or store user data on our database?
So
Soumya,
yeah,
Amit.
All right. Let me go first, and then maybe Amit, you can add. See, this law neither this law nor any other privacy law will mandate and tell you how many days you need to maintain, right? It is on a need basis. So if so the very first thing is the need for the purpose for which you are collected. And in addition to that, you will also have to see if there are other regulatory or legal requirements for which you have to maintain the data. For example, financial reporting is probably one thing that we can easily grasp, right? We have requirements on maintaining financial reporting. So, but there are other requirements such as employment laws and all. So based on the need for which you have collected that information, and the presence or absence of any other regulatory requirements, is when a organization has to take a call and document it very most preferably in some kind of like a record retention process or retention procedure, and then you take the call. But at all points of time, we would have to justify and say, why is it that we have taken this number as our record retention period?
Awesome. We can take another question, and Amit, if you can answer that. This question is from Malay Shah. It would be great to understand how aggregate data is treated as opposed to individual data from a DPDP Act perspective.
Thanks, Shashwat. And thanks, Malay, for asking this question. See, aggregated data, if there are multiple sections, and multiple things which deal in the DPDP. Now, how aggregated data is treated as, let's say, some trends of how one product is being sold in one particular market. Okay, if you can separate the individual from the aggregated data, then it is exempt. You can use it for statistical purpose. You can use it for research purposes and such purposes, which are specifically exempted from in the law. Okay, but if you are able to zero it down to the individual, back to the individual. Let's say I made 10 times I went to DMart and I made purchases. Now, DMart analyzing the sales figure of one particular product which they are selling in one particular month, that is at an aggregated level, that is fine. But if they are able to zero it down to me, that Amit is going to the store and he is purchasing this product, or this product is being, if they are able to get back to the individual with that data or with that research which they have done, or use that analysis which they have done and do some targeted advertisements of anything of that sort, that is something which will be frowned upon by the authorities or by the law.
Let's take one last question. This is from Nikita Kale. very important question that if we have taken the user consent to store personal data when the user was, say, purchasing an X product, can the same thing be used for purchasing Y product from the same brand? Soumya?
Yeah, so this is like a little bit of a nuanced answer is that when you are collecting the consent, what exactly are you collecting the consent for? If your consent very clearly says that this is for like say like sales purposes or for order fulfillment, right? Then it is fine. But if you are saying that this is for selling product X, then you will not be able to use it. So when you are crafting your consent also, you need to make sure that you cover all these areas appropriately, right? So you would have to craft your consent in such a way, and it's a little bit of a of a managing balancing the scales, because you cannot take a consent and say I for any of my business purposes, right? You will not be able to take it at that level, but you can say that this is for order fulfillment or for selling you the goods, right? That at that level, you will still be able to take it. Right?
Awesome. With that, we are close to the end of the show. What I want to do is, with each one of you, two very important aspects on DPDP that people should keep in mind. So let me start with Amit. What are the two actionables for principles in DPDP law? And very short answer, if possible, because we are almost hitting the clock.
There are two key things that you should remember. Number one is DPDPA has a unique position when it says that if you raise a frivolous request, then there is a fine for the data subject as well, or the data principal as well, which is not existent in EU or any other structure. So that like if I raise a frivolous request to DMA or any other company which is having my data, and knowing that they don't have my data or anything of that sort, then there may be fines on USD. Okay, some fines on you, like it's small amount of some 10K or something, but still this thing is there. Other thing which you have to remember is what rights you have, okay, which is a very, very important aspect. If you are not aware of what rights you have, it will be a tough thing for you to just to handle your data. The companies will be using it as per their convenience. So you should always be aware, read the privacy policies or any document which the company gives you before you take on I agree. Okay.
Awesome. Soumya, for a CPG company, which are the two most important things that they should keep in mind to ensure that compliance is there?
I will in fact make it even shorter, right? For a CPG company or for any organization, know your data. That is the one thing that you have to keep in mind. First is identify what is the data you're processing, then know and understand whether this is PII or it is potential PII, right? If any organization can narrow this down and lock this down, you're probably halfway home towards fulfilling all your commitments, just knowing your data. So I would say that that is probably like 1, 2, 3, and 4 of your important things to do.
So what you are saying basically is KYC will now become KYD. Great.
Yeah, not just KYC, because we need to keep in mind, and it is more a lot important from a CPG aspect also, is that because we have the companies which have a lot of employees, right? Employees also have privacy information. So we should not look at it from the narrow lens to say that I'm only going to protect my customer data. I have an obligation to protect my customer data, my employee data, my third parties data, or any other personal data that I'm collecting of any stakeholder, right? So I would say like, yes, know your data.
Super. That was really insightful. Varun, as a data processor, what are the two very important and very short answer, because we are running completely out of time? Very short answer, two important things to ensure that you are data compliant.
Uh, I think two main things would be, one is data processing operations. I think we have to be very sure of what are the processing operations we are doing, and it is only, I think, fiduciary should also know what processor is doing on their behalf, and processor should also know this is a processing operation, and this is I'm doing on personal data. And outside of it, I'm not touching data in any form, because this is extremely important to be compliant. And I think this also pose a great opportunity for, I say, processor and a fiduciary to gain trust, and I would say establish themselves as a, I would say, privacy leader in your space, and to your customers, to your other stakeholders, to attract talent. So I think it is something that is very strategic also in place. But yeah, limit your processing operations and know your processing operation. I think these two would be the main points.
Awesome, Varun. With that, we can wrap up the show. This is a thought leadership series. We will continue doing this. Thank you, audience, for asking such great questions. This was really insightful for me. We can continue this conversation on LinkedIn. The same thing will be posted on LinkedIn as well as on our website. So please go and visit. And if there are any questions, please ask it on our LinkedIn site, and we will answer that. With that, thank you very much. Thank you, experts, Amit, Soumya, and Varun. This was a great show, and I thoroughly enjoyed it. Thank you, everyone.
Thank you.
Bye-bye.
Thanks, everyone.
Thanks, everyone.
Thank you, everyone.
Thank
Bye.
you, guys.